The delivery of the judgment in the Brantley election case has brought to the fore again the ugly and vexed issue of our electoral system. Whatever the judgment on appeal, this will not be the last dispute over the system if it remains as is. Our leaders need to find the moral resolve, put principle and country above self, and legislate a proper system. Until then, our democracy will be incomplete and our country's name will remain tarnished. Our Constitution established a broad framework of the system, but left the rules to be established by legislation. The history since independence has shown that this was not a wise move. The Constitution failed to give the Electoral Commission the teeth needed to control a recalcitrant supervisor. That was plain in this case, with the Supervisor of Elections openly defying the Commission. The following statement from the judgment stands out. The judge wrote, and I quote, "It is troubling the relaxed way in which non-compliance of the law is regarded." End of quote. The supervisor was found to have deliberately aimed to subvert the rights of voters. Strong language. The registration officer was found to have engaged in deliberate disenfranchisement and reckless disregard of the importance of observing the rules of natural justice. These conclusions are based on findings of fact made by the learned judge, which are unlikely to be overturned on appeal. They constitute a severe indictment of these officers. The position of the Supervisor of Elections and the registration officer is untenable in the light of those findings. They should both resign or be fired. Unfortunately also, the Constitution left to the legislature the establishment of qualifications for registration of voters. The result has been, from 1984 to the present, shallow legislation easily capable of abuse. The framers of the Constitution provided for a constituency system, but did not carefully consider the effect of the overseas vote, which defeats the purpose of a constituency system. The proper system to accommodate the overseas vote is one of proportional representation without constituencies. I do not, however, and sadly, think that there is, at least not at present, the enlightenment needed to move to that system. Hopefully the next generation of leaders will be more enlightened. If we are to stick with the constituency system, then the legislation should be amended to provide, beyond all doubt, that for a person to qualify to vote in a constituency, he or she should prove actual continuous residence in that constituency. Or, if he or she resides overseas, substantial direct or family ties with the constituency. There should be clear and transparent procedures for determining where a voter is entitled to be registered, rather than the free-for-all which now prevails. A strong burden of proving that one is entitled to be registered in a particular constituency at the time of registration should rest upon the person applying to be registered. Likewise, if a person's registration in a constituency is objected to, the registrant should prove his residence. The so-called confirmation process was intended principally to entrench the prior manipulation of the system. It is being unraveled by the legal finding of Mr. Justice Bell, supported by Mr. Justice Jones in the Brantley case, that a confirmed voter may be removed from the constituency list on which he or she was confirmed. That is going to open up another can of worms in the whole federation and lead to plenty more court cases as we move towards the next general election. This can and should be avoided now. Also, some of the electoral regulations are unconstitutional as they contravene the fundamental right of the citizen to vote. Where regulations do not adequately accommodate that right or imperil it, they are unconstitutional. That right is sacrosanct, and everything possible should be done to give full effect to it, not to obstruct it. We profess, after 28 years of independence, to be a responsible member of the regional, hemispheric, and international communities. We pretend to be a constitutional democracy, but yet we persist with a farce of an electoral system which has brought rebuke from the courts, from CARICOM, and from the OAS. Thank God that we still have our legal system to which we can turn for redress, and freedom of speech to complain about irregularities. However, we would be much more productive and stable as a nation if we were to cure this sore once and for all. The unprincipled, prevailing attitudes of win at all costs and tit for tat are leading us backwards. The Brantley judgment may prove to be a landmark one in respect of the use of government-owned media. This has been a vexed matter from pre-independence days. It is high time that government show maturity and recognize the constitutional right of freedom of expression by providing access to ZIZ to all political parties. I remind you that in 1994, the Four Seasons Accord was signed to help bring the electoral dispute at the time to an end. The Accord agreed to, and I quote, general monitoring of ZIZ radio and television to establish a professional institution and to protect its abuse for political purposes. 17 years later, the Prime Minister who signed and benefited from the Accord has forgotten that aspect of it and is still perpetuating the monopoly of ZIZ by the government. The fundamental right to vote may be under challenge from the powers that be, but the fundamental right of free speech is growing and will be unstoppable if the citizenry continue to exercise it as strongly as they have been doing of late. The government may as well acknowledge that fact and free up ZIZ before the court does so.